Yes, sir, you are clear and audible.
Yeah, thank you. So at the outset, I thank ICSI IIP for providing me this opportunity to present today's session on a very, very important topic of submission and verification of claims. The entire CIRP, we call CIRP as a creditors driven process. Creditors take the control of management of the company or a corporate debtor which has gone into insolvency, the CIRP process or liquidation process. So it's a creditors driven process, and it is very, very important to identify as to who are those creditors, what category or what type of creditors those are, what is their authority as regards their participation and control, what is their amount involved, whether the claim is admissible or not. So in my view, this is also a very, very essential and important topic as regards CRP is concerned. Submission and verification of claim, in my view, defines or determines the fate of your entire CRP. It has been observed in many of the cases that there has been an error on the part of IRPs or RPs while determining the claim. Sometimes it has happened the related parties are there who form part of being financial creditor, being part of committee, or sometimes uh, some claim has to be admitted and that person is not made part of CRP. Because of this delay, ongoing basis, the process is there for 180 days and it doesn't stop anywhere. So ongoing basis, committee of creditors meetings take place. Uh, Acceptance or rejection of claim determines whether a person will be a part of that COC meeting or not. And that's where it affects the ultimate functioning of committee of creditors, right from review of the claim of creditors till the analysis or vetting of resolution plan which are available. So whether acceptance or rejection of claim of any person determines his participation. So if at all a genuine claim is there and I as an insolvency professional do not accept the claim, do not accept that particular claim, that particular creditor is deprived from voting into the COC meeting. And inverse is also true. So if a person is a financial creditor, but somehow it is related, and I give him an opportunity to participate and vote, so that is again responsibility cast upon me. What I wish to cover in today's presentation, I'll start with the presentation. What I wish to cover in today's presentation is all the key aspects of uh, submission and verification of claims. I hope my presentation is visible to you. Yeah.
Yes, sir.
So submission and verification of claims under IBC. This is a quick summary of what I wish to cover today. A refresher of introduction, a refresher of overview of IBC provisions. Situations when claims are to be filed under IBC. So what are the scenarios in which we file the claim? Important definitions, of course, pertaining to the claim, filing of claim and submission and verification of claims. So pertaining to those definitions, we'll be looking upon. Forms for filing the claims and various regulations of IBC. Yes, important definition pertaining to liquidation as well as CRP I'll be covering. Model timeline for CRP will be looking upon. Claim under CRP relevant regulations. So claim related regulations I'll be covering upon. Then claim related to liquidation. We'll also touch upon, I'll also share my experience as regards claims which I have received in voluntary liquidation process, or I got an experience of being a part of CRP in a home buyers project where I was from home buyers, advisor to home buyers who were not at all aware of as to why the petition has been admitted, why they had just booked the flats with a corporate debtor. None of them was aware about what IBC and what CRP is, but some person did not pay the money, and because of which the petition got admitted and their flats are stuck up. So right from spreading an awareness, telling them the 200 to 50 flat buyers, the explaining them about the CRP process and spreading an awareness, and right from submission of their claims. So I got an opportunity to be part of such assignment of submission of claims of class of creditors who are the home buyers. Then claims under liquidation relevant provision. common mistakes which are there. Now, 10 onwards, I'll be covering practical aspects. So theory will touch upon, and I'll share my practical experiences also while handling the claims, the common mistakes which are there in the claim forms, some tips or some what we call as points which RP has to take into RP or I have to RP has to take into consideration while submission of claims. Effective process for IRP, RP in handling the claims, that is how the data has to be structured, how I maintain the data in the Excel format, or what is the categorization, how I maintain the data. Illustrative list of claims documents, a small list is there of which category of creditor he or he is, and what documents are required to be attached. I'll be discussing orders of IBBI, the disciplinary committee, of course, on the claims. Now, some 8, 10 or 12, 13 orders are there. We'll go through those where the IPs went wrong. Uh, those orders basically give us an idea as to where things go wrong, and from them we can learn as to what mistakes are not to be committed. Then latest judgments under recent judgments as regards claims. I'll be covering, and that we can take up the questions if any. So this way we'll be going. Again, I always say, and from my experience, that IBC has got opportunities, bundle of opportunities. It has opened a new area altogether for professionals. It has got opportunities which are stated in the law, as well as those opportunities which are not specifically stated in the law. A person can have ample opportunities even if he's an RP or not an RP. So this also is a great exercise of preparing and filing claim forms, or assisting the insolvency professional, IRP or RPs, in verification of claims. Of course, a RP cannot delegate his work to anyone or shift his responsibility as regards verification of claim is concerned, IRP or RP. But yes, he can certainly take assistance depending upon the volume of work, and entire responsibility of verification of claims is of course on him. But there also we as IP can play a very, very important role by assisting in such exercise. Yes, with this, we start with the presentation. IBC, we all know it's a law relating to why it is called as code. Why it is called as code? Because it's a bundle of law. It gives a foolproof solution as regards resolution of or insolvency of corporate persons, partnership firms, individuals. Although partnership firms and individuals provisions are not yet notified, their IBC, entire IBC works on timeline, time-bound manner. So 180 days time is given to us. In the model bylaws, we'll be looking at the timeline as to what and when the process is there. So these 180 days are not affected by any holidays, any Sundays, anything in between. So those are to be strictly followed. Then maximization of value of assets. There are certain cases wherein disciplinary committee, the cases which we are discussing, will be discussing. Disciplinary committee had held that because of negligence or because of casual approach or laziness of certain resolution professionals, the maximization of value of corporate debtor could not be achieved. These things happen. Then to promote the enterprise, increase entrepreneurship, increase the credibility. Of course, bank will be more inclined nowadays if they are getting fast track solution as regards recovery or insolvency process. Then priority of payment of government dues. We all know government has taken a backseat now in CRP process. Then Insolvency and Bankruptcy Board of India, IBBI, who is the main regulator, who it ensures the implementation and execution of all the provisions of law as well as regulations under the IBC. It governs all the pillars under the Insolvency and Bankruptcy Code. To provide a painless revival mechanism, cross-border insolvency, there is a provision for it, and resolve bad debts problem in case of banks. Now, IBC, in the refresher only, it covers individuals, partnerships, LLPs. Adjudicating authorities are DRT in case DRT in case of individual partnership firm. NCLT, NCLT in corporate person in case of corporate persons. IBBI regulates and oversees IPs, IPAs, information utility. Agencies will develop professional standard, code of conduct and ethics has been prescribed to us. So we are governed by IBBI as well as IPAs. Code lays down a swift process of 180 days applicable to corporate person, can be extended by 90 days in if sufficient cause is being showed. Strictly, this timeline has to be followed. Management of corporate person in the hands of IRP, RP, of course, under the supervision of and control of the committee of creditors. Resolution plan to be approved. There is a resolution plan which will have to be approved by 66%. And if resolution plan is not there, if early resolution is passed by committee of creditors for a dissolution, then the company goes for liquidation. Legislative structure, we are aware of it. IBC is divided into 5 parts in this manner. I'll be sharing, of course, this PPT. So this is distribution of a legal framework of IBC, the structure of IBC, the 12 schedules, 1 to 11 provide for amendment to be carried out in other statutes. Adjudicating authority, we already discussed. Now, these are the pillar members governed by IBBI. The IBBI, IPs, insolvency professionals, IPAs, adjudicating authorities, and information utility. There is only one information utility, NESL, in India. So all these are governed by the Insolvency and Bankruptcy Board of India, and ensuring that they function as per the regulations prescribed, respective resolution prescribed therein. At regular intervals, IBBI carries out inspection investigation pursuant to section 218 into the affairs of these pillars of IBC to ensure that whether the functioning is exactly as per the provisions of regulations and the respective regulations and provisions of IBC. Now, let's start with the claims part. So this was a refresher about IBC. Let's start with the claims part. Situation when we submit a claim under IBC. So corporate insolvency resolution process, CRP regulations, the Regulation 7 onwards, the provisions relating to claims are there. We'll be discussing these provisions, each and every provisions in detail. CIRP and liquidation, I'll be focusing more, especially the amendments which have taken place in September 23, pertaining to submission of claim, updation of claim, and verification of claim. So those I'll be highlighting. These regulations we'll be studying in detail and discussing in detail. So claim by operational creditor starts onwards, Regulation 7. Then scenario 2 is liquidation process, Regulation 16 onwards of liquidation regulations. This is a scenario wherein again claims are required to be submitted under IBC. Voluntary liquidation process under section 59 of IBC, read with voluntary liquidation process regulations. Here again, there is a mechanism for publishing a newspaper advertisement and invitation of claims from different categories of these regulations. Fast track insolvency regulation process, depending upon the size of entity, the fast track manner the CIRP takes place. A separate set of regulations, and of course separate forms are there for them. Pre-packed insolvency resolution process, there is a mechanism for a list of claims. However, we won't be discussing these provisions in detail. Most relevant and most what we call as used provisions are CIRP provisions, liquidation provisions, or voluntary liquidation provisions. We'll focus those provisions. Insolvency resolution of personal guarantors of corporate debtor. Then in this scenario, we provide for claim, public notices there and claims are accepted. Then application to bankruptcy process of personal guarantors to corporate debtor regulations, the bankruptcy provision. These were the rules. These are the rules, these are the regulations. So these are the situations in which a person or there is a provision for publishing an advertisement or invitation of claim and filing of claim by different categories of creditors or stakeholders under IBC. Now, forms for filing the claims, different forms. Like I said, liquidation regulations, the form is C as regards operational creditor, D in case of financial creditor. Also, I have covered the manner in which the forms are to be submitted. In some of the cases, it is in person or by post or by electronic means. Some in case of financial creditors, it is compulsory in electronic means only. So that way I have highlighted under liquidation regulations. These are the forms prescribed in Schedule 2. In CRP regulation, Schedule 1 prescribes the form. Form B onward, the claim form start. While discussing the respective regulations, we'll be again discussing those forms. And that way, these voluntary liquidation prescribed forms are there. Slightly here and there, but the nomenclature of the form is same: B, C, D, sometimes C, AA, E, F. So that's the nomenclature of forms. One point I wish to state over here is on the IBBI website under the field download, you can download the version of these forms, Word copy of these forms. These are downloadable. Those are available in the database of the IBBI. So IBBI website downloads, you will be able to download all these claim forms in Word format. So if at all those are required to be provided to the claimant, these can be provided by the liquidator. CRP process, again, a quick refresher of CRP process. We'll be focusing on one part of it today, that is filing and verification of claims. But overview of CRP process, the process starts from admission of application, section 7, section 9, section 10, in event of default. Of course, the voluntary winding of the process is a bit different, but in case of CRP, section 7, section 9, section 10, the petitions are submitted to adjudicating authority. Adjudicating authority, upon being satisfied that there is a default and upon certain conditions, it admits the petition. Upon admission of petition, IRP is appointed. Then IRP, there are these duties which are being prescribed under section 18 of IBC. That is what duties are required to be performed by an insolvency resolution professional. Section 18, that is collating the claims, is one of the duties. Then taking control of assets, liabilities, the affairs or entire business of the corporate debtor. Collation of claims and constitution of committee of creditors by insolvency interim resolution professional. So IRP collates the claim. Appointment of resolution professional. So RP sometimes is continued or replaced by new RP. IRP is continued or replaced. Then a document called information memorandum is prepared, containing the detailed metrics of everything, based upon which expression of interest is published in Form G, and resolution applicant, upon providing affidavit and undertaking as to confidentiality, are allowed to the access to this information memorandum, based upon which they submit the resolution plan for examination and further consideration and approval of committee of creditors. Upon approval of committee of creditors, suppose there is approved by committee of creditors, it goes to the adjudicating authority, and adjudicating authority may either approve it or reject it depending upon the case. When the plan is approved, then the CIRP implementation take place. When it is rejected, it goes for liquidation. So this is an overview of CIRP. Model timeline for CIRP. I'll stop this presentation and share my entire screen, wherein we'll go through the model. Yeah, I'll be sharing the entire screen. Regulation 40A of CRP regulations. I hope you're able to see this. I have highlighted the portion which we'll be covering more today. So this is a model CRP regulations. The 180 days timeline starts from here. T is the place of start, that is a 0 day. Commencement of CRC date on which appointment of IIP takes place. Then a public announcement within 3 days. The regulations prescribe 3 days. That is immediate, means that is 3 days. T plus 3. Then submission of claims within 14 days from appointment of IRP. Like I said, there are amendments in regulation 12, 12A, 13, the verification 13(1)B especially. This is the area or submission of claims or verification of claims. This cannot be said as a straight process or a simple process. A lot of patience is required as regards IP is concerned or IRP is concerned, because there cannot be a straight formula for this. Because why I'm saying so is there are varied judgments from different benches on similar matter. Different views are taken by adjudicating authority. Maybe that is based upon, or of course that is based upon the facts of the case, the situation, the circumstances, the category of claimant. Say suppose it is a workman, the stand taken by adjudicating authority is slightly different. Say the time based upon the timeline and the acceptance, verification or rejection of claim. Say suppose it is a financial creditor, the stand is different, sometimes different. Say it's operational creditor, then it's certain different views are taken. So there cannot be a straight formula. And of course here under CRP, IP mainly is collecting the claims, verifying the authenticity and validity of the claims. So he's not an adjudicating officer in this. He does not have adjudication power here. He has to just collate the claims. He has to compile or collect the claims and verify the accuracy and correctness of these claims. So within 14 days, the claims are to be verified. Verification of claim received. Application to the for appointment of authorized representative in case of class or classes of creditors, maybe home buyers, debenture holders, class of financial creditors. In that case, authorized representative has to be appointed. Choice of 3 is given, and out of which the in response to the advertisement, the claimant will prescribe as to who will be appointed or who they choose as an AR. Report certifying constitution of COC, first meeting of CSC within 7 days, and so on. So this is a model timeline. Of course, I'll be sharing this model timeline also. It goes up to 180 days. So here, if the resolution plan is approved in ArcelorMittal case, Satish Kumar Gupta, it has been prescribed that all the consent authorities to follow this model timeline. I'll be discussing at the end, like I said, 7-8 cases relating to disciplinary committee, wherein these timelines are also verified. Orders are also passed based upon wherever these timelines are not complied. So we'll be going through that as well. This is a model timeline. Coming back to the presentation. Claims under CIRP. Now, important definitions will be covering, of course, pertaining to the claims. When we are discussing about the claims, of course, the definition of claim will have to be discussed. Claim, basically, what is important in this? Right to payment or right to remedy, which gives rise to the right to payment. So what is important is right to payment. Sometimes a person directly has a right to payment. Such payment, whether or not such right is reduced in judgment, fixed, disputed, undisputed, legal, equitable, secured, unsecured. Suppose I supply goods, I'm eligible to get the payment. So that's a right to payment. Right to remedy for breach of contract. Let's take an example of home buyers again. I have booked a flat or I have booked a commercial shop with a builder. I have a right to get that shop. But if there is a breach of contract, if there is a breach against that, I'm eligible to get my payment back. So I'm eligible to get some interest, penal interest, or whatever the terms and conditions has been agreed in the builder-buyer agreement. So that is a right to remedy for a breach. Again, the breach gives rise to the payment. So claim means right to payment and right to remedy, where such breach gives right to payment. Whether or not such right is reduced in judgment, fixed, matured, unmatured, disputed, undisputed, secured, or unsecured. So that is where the claim is defined under section 26 of IBC. Then creditor means any person to whom a debt is owed, includes a financial creditor, operational creditor, secured creditor, unsecured creditor, and decree holder. Debt is a liability. There is a difference in claim and debt. Claim is a bit wider concept. It may or may not create a debt. Claim is filed, and there are chances that it may get admitted. When it is admitted, it becomes debt due. When it is partially admitted, of course, partially rejected or completely rejected, that determines whether it is debt or a liability or not. So claim is different. It's a bit wider concept or a previous stage. After that, then it is admitted or part of it is admitted. The admitted portion becomes debt. Debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt or an operational debt. Moving ahead, secured creditor means a creditor in favor of whom security interest is created. Security interest means title or interest or claim of property created in favor or provided for a secured creditor by transaction which secures payment. So what is essential here is some security has been provided for securing the repayment. A charge is created, of course. So encumbrance, charge, mortgage, hypothecation, assignment has taken place. A loan which is backed by some security. In one of the cases, High Court had passed order in favor of decree in favor of one of the creditors, in which it has worded that payment shall be secured. Payment of this person shall be secured. IRP should ensure the payment of this person. So by that word, he inferred that that is a secured creditor. So it was held otherwise. He was definitely not. So for being a security or being a secured creation of security interest, it has to be backed by some asset. So that is security interest, that is charge, encumbrance, for performance of any obligation, provided that security interest shall not include performance guarantee. Performance guarantee specifically excluded from this. Financial creditor means any person to whom financial debt is owed. What is important over here is, of course, the legally assigned debt also, factoring services or takeover of loan. In that case, financial debt, a creditor it covers. Financial debt, uh, slightly lengthy definition, but it covers all the aspects. It throws light as regards uh, definition of financial debt is concerned. So what is essential is the consideration for time value of money. Whenever money is given with an intention to get a repayment of it, some interest, along with some interest, that is borrowings or lending by any person. So that is a financial debt. Financial debt means a debt along with interest, if any, which is disbursed against the consideration for time value of money. When money is money is borrowed against the payment of interest, or acceptance under any credit facility. Any amount is accepted against credit facility. Any amount raised pursuant to note purchase facility. So note purchase facility is basically again issuing some kind of instrument. Notes are instruments which are issued against which the money is raised, like bonds, notes, debentures, loan stock, or any similar instrument. By issuing instruments, corporate debtor or some person raises money that is again covered under financial debt. The amount of liability in respect of lease or hire purchase contract, which is deemed to be financial capital lease according to accounting standards or other prescribed accounting policies. Receivables sold or discounted, like factoring services, we all know debtors are purchased at a discount rate. So in that case, that is a factoring service. Normally, financial institutions provide these services. Any amount raised out of transaction, including forward sale or purchase agreement having commercial effect of borrowing. So that is borrowing, of course. This is important, inserted by later on an amendment, and a lot of ambiguity was resolved and solved up to much extent. So that is home buyers, the real estate project as defined under RERA and allotee of a unit as defined under RERA will be considered as a financial debt. Any amount raised from an allotee under a real estate project shall be deemed to be having a commercial effect of borrowing. So home buyers will come under this category pursuant to section 581(21). Any derivative transaction entered into in connection with protection against. So derivatives transactions, speculation into the market, only up to the value of market rate. So, sometimes hedging or speculation with an intention to avoid the risk, cover up the risk, or protection against the or benefit from fluctuation, those transactions. Then counter indemnity and warranty in obligation in respect of guarantee, indemnity, bond, documentary credit, any amount of liability in respect of any guarantee or indemnity for any clauses referred to it. So any guarantee or indemnity provided for A to H above will also be covered in this clause. So that is about financial debt. Operational creditor means a person to whom an operational debt is owed and includes any person to whom has been legally assigned or transferred. So any operational debt, it's important here to discuss then operational debt means a claim in respect of provision of goods and services, employment. It may be noted that in case of operational debt, it's a regular routine business transaction where goods are purchased or sold or services are availed and payment is due against them. Employment is covered into this. Government dues are covered into this. So operational debt, claim with respect to provisions of goods or services, including employment or a debt in respect of payment assigned under any law for the timing in force payable to government, state government, or any local authority is termed as or categorized as operational debt. Class of creditors will be discussing about class of creditors. So here what is important is 10 financial creditors, at least 10 financial creditors. Those will be, that is a number, or that number or higher number will be termed as a class of creditors, 21(6)(a)(b). Now relevant CIRP regulations. The CIRP process starts. Short title and extent of definitions were there. We saw a few important definitions pertaining to claims. Again, eligibility of resolution professional. We won't be discussing these in detail. We'll be discussing mainly focusing on claim aspects of it. So Regulation 3, eligibility of resolution professional. We all know resolution professional should be able to act as an independent director, should be an independent director, should be independent of the corporate debtor, any related party or his relative or any kind of services he has provided in the past, he becomes disqualified. So eligibility criteria is prescribed in Regulation 3. Regulation 3A prescribes for assistance and cooperation of person of corporate debtor. As soon as the IRP is appointed, uh, the management or the corporate debtor or the past management, suspended directors, suspended boards or personnel are under an obligation to assist, provide full cooperation to the insolvency resolution professional to take over the affairs of the corporate debtor, right from handover of books, providing any information or giving possession of any data or property which is there in their possession. So cooperation has to be extended. Access to books of accounts. IRP gets a power to access to the books of accounts from corporate debtor, consultants, advisors, accountants, everyone. He gets an account to access to the books of accounts for execution and performing his duties. Choice of authorized representative is given in advertisement out of three. One authorized representative. Of course, the same eligibility criteria are applicable to the authorized representative. Also, a person cannot be appointed as an authorized representative if he is related. He should also be independent. He should be able. He should also fulfill the criteria of being appointed as an IRP. So he should be that independent. He will be representing certain class of creditors, a group of creditors. Disclosure of change in name and address of corporate debtor. So that has to be disclosed if at all any change is there in the last 2 years. So that has to be disclosed. Process email. So it is mandatory to, and of course, it is advisable. It is mandatory as per these regulations to have a separate email. You might have seen in CRP process, suppose XYZ company CRP is going on. They generally open a separate email address for that. Sometimes even a website is there. That's xyzcrp@so-and-so.com. So that's the email address specifically required to be opened by a separate email address through which entire communication should take place when the IRP hands over the affairs to the RP in event of RP is the new person. At that time, he is under an obligation to hand over the possession of this email to the RP. Opening a separate bank account for each real estate project. So as per this regulation, RERA project, for each project, a separate bank account will have to be opened. Extortionate credit transaction is exorbitant payment made to any party. Those are extortionate credit transaction. There is a mechanism wherein RP is under an obligation to submit a claim or file an application. He has to make his mind. He has to identify as to whether extortion credit transactions have taken place. In that event, he is under obligation to make his mind first to identify whether determine whether such kind of transactions have taken place, extortion credit transaction, preferential transaction, any benefit is passed on, and in that event make appropriate order application to adjudicating authority and take appropriate directions for corrective actions. Now claim process starts from public announcement. The claim process starts from public announcement, and insolvency professional shall make a public announcement not later than 3 days. So not later than three days on the appointment of his IRP. Advertisement has to be given in form number A of Schedule 1. All the forms are prescribed. Here there is a discretion to the IRP as to where, in which location or which area the advertisement has to be published. Of course, where the registered office is situated, there our principal office is situated, the advertisement will have to be given in English as well as vernacular language. Apart from that, if there are material business operations carried out to those locations also, the advertisement is required to be given by IRP. Public announcement will be placed on the website of CD, if any, and board. So on IBBI website, we upload it. And if corporate debtor has a website, then this advertisement also has to be placed on the corporate debtor website. In the orders which will be referring at the end, in one of the cases, it has happened that advertisement was not placed on the website of corporate debtor. Reply given by the IP was that corporate debtor does not have an active website, although it was there. In one of the correspondence, IBBA had noted, the disciplinary committee identified that there is only one website of corporate debtor. So IP failed in uploading that order on the website or placing on the website. And accordingly, appropriate directions were given against him. Public announcement to state the claim forms can be downloaded or forms. So where the state claim forms are there, the path can be given as the case may be. So which appropriate form is there that advertisement should prescribe. Offer of choice of insolvency professional identified under 4A to be an authorized representative. So IPs who are independent, like we discussed, can be appointed as authorized representative. So the class of creditors have a choice to choose the person, choice to out of three. So three options are given, out of which they'll have to choose one option who will act as authorized representative. Advertisement to provide last date for submission of claim, which shall be 14 days from the date of appointment of insolvency resolution professional. We'll be discussing this provision in detail regarding submission, that is timeline within how many days, and of course that is pertaining to CIRP only. Under CIRP, after amendment of September 23, what are the timelines as to till what date a claim can be filed? That we'll be discussing in detail. For liquidation, of course, that higher timeline is not there, or that liberty or flexibility is not there. It is only 30 days. Applicant shall bear the expenses of cost of advertisement, which may be reimbursement by the to the extent as is ratified by them by COC. So advertisement is a trigger point where the claim process starts once the advertisement is published. Again, earlier it used to happen, especially in case of government dues. This new regulation is there, regulation 6A. This also fixes one matter, one ambiguity. Earlier, what used to happen is, especially in case of real estate projects, builders, buyer builders projects, corporate debtor has a record of flat booking. Flats are booked. However, the claimant has not filed a claim for that flat. Or there are government dues appearing in the books, like GST dues are there, income tax dues are there, PF dues are there, sales tax, customs dues are there in appearing in the records of financial of the corporate debtor. And because the claim is not filed within prescribed time, RPs used to reject that claim. Now it won't happen that way. Interim resolution professional is cast upon the responsibility to send a communication. In the duties under section 18 of code, they have a responsibility to verify the books, take the possession control, and also they have to go back and study 2 years or 1 year or 2 years related parties there. So based upon that, to go and check the past records based upon that. So he's under an obligation to study the corporate debtors accounts wherein the entries are there, and he has to take an effort of communicating to those liabilities which are appearing in the books and have not filed the claim. So interim resolution professionals shall send a communication along with a copy of public announcement with the under regulation 6 to all the creditors as per the last available books of accounts of the corporate debtor through post or electronic means wherever the information for communication is available. Of course, wherever communication is not possible, newspaper advertisement will serve the purpose. So this is again regulation introduced later on. Otherwise, it used to happen that prescribed time limit is over, and RP used to take a stand that you go approach the adjudicating authority and then get the claim adjust, and then if upon that directions, I'll include that claim. So here it doesn't happen that way now. RP is also under an obligation to study the entire books of accounts records which are last available and communicate with the concerned parties and advise them to file appropriate reply or claim, submit their claim in the prescribed form. Claims by operational creditor. Now, regulation 7, claims by operational creditor. We already saw operational creditors are the creditors who are suppliers of goods or services, are employees, or the government dues are there. For them, this form is there. Claim is such an area where, like I said, different practices are followed. RPs or IRPs have to, or liquidator have to have a lot of patience as regards this is there. Now, what happened in one of our cases recently is we did the voluntary winding up one company. The affairs of the company were completely wound up. And after that, we approached the adjudicating authority, filed the application under section 59, and the order for the same was also passed. Now, dissolution application has been approved. Dissolution order has come in the month of July. And last month, I have received a claim. Of course, after the dissolution order, I have received from PF officer, the Provident Fund officer. Before the application was made, PF number was surrendered. PS assessment for 5 years took place. Dues were calculated. Dues were paid along with interest. Everything was complied, and the application for surrender was approved. Only thing was that on the website, the surrender status was not there. They did not update the surrender status. Otherwise, entire affairs for the assessment took place, everything took place. And the claim was filed to me last month, in the month of September. So this happens, the claims keep on coming, and at what stage the claim has come. That really matters actually. So where it stands in that case. Of course, we'll be discussing judgments on that as well. Yes, coming back to Regulation 7, person claiming to be an operational creditor other than workman or an employee to submit the claim. Other than workman and employee, because they have a separate form. Form number B has to be filed. These forms are prescribed. They are along with declarations or affidavits are embedded in those forms. Submission of by person or by post or by electronic means. Person may submit supplementary documents later on till constitution of committee of creditors. It may be noted at this point that once I've submitted the claim, I can also revise the claim as and when I get some proof, I get some, so I can update the claim. I can keep on updating the claim, a genuine claim, along with supporting document, of course. So it's not a one-time exercise, and once this is done, I don't have any other remedy in future. So it may happen that the claim keep on revising. It may happen that additional claim may be there. In case of financial creditor, the interest component may not be included. So that way, because in case of CIRP in liquidation date, there is a difference in that. So the claim up to which has to be acted. In case of CIRP, liquidation commencement date, the date of admission, up to that date, the claims are required to be filed. In case of liquidation, up to liquidation commencement date, the amount outstanding on that date, the claim are to be updated till that date. So there is a possibility that there is a revision. It may also be possible there are contingencies in the claim. It may be also possible that there are contingencies in the claim, and once clarity is there, at that time, RP exercises the best judgment and he finalizes the claim. But once the contingency is crystallized, the claim is known, then in that case, updation of claim is possible. Existence of date due. What normally we attach to these forms is, of course, the records of information utility. Of course, those are, if those are there in case of operational creditor, I have rarely seen. Nowadays, NCLT has started raising queries when you submit Section 9 application about for information utility, records of information utility for filing the claim. So information utility, other relevant document like contract for sale, supply of goods, invoices, purchase orders. Normally we attach purchase order, invoice, email communication correspondence, terms and conditions agreement basically, which is there, or reminders or bank statements, GST details. That's very, very important. GST details, TDS details, tax deducted source. GST they have specifically mentioned now in the regulations. Copies of GSTR1 and GSTR3 returns filed by. So if you have raised tax invoice, of course, wherever GST is applicable. So after June 22, GST particulars are also included. GST has to be, details are to be submitted. We also attach TDS related provisions, tax related filings also. If on the invoice tax TDS is there, then we also attach those. So GSTR is mandatory now, 1 and 2 in if the GST is applicable to that entity. So this way the claim of operational creditor is filed. It is advisable to file along with this or each and every document to the satisfaction in a proper chronology to the resolution IRP so that the claim gets admitted. Claims by financial creditors. Financial creditors are banks, financial institutions normally. And Form C is there. For them, electronic filing is mandatory. Form has to be filed in electronic form only. Maybe taken into consideration the volume of documentation. Maybe the loan runs into 3 years, 4 years, 5 years, 10 years span of time. And lot of documentation is there. So to have a proper documentation, paperwork in a systematic manner, they have been mandatorily required to submit a claim in electronic form. They also may submit supplementary document. What proof are there? Nowadays, information utility, yes, data on information utility for them is mandatory. For banks and financial institutions, it's mandatory to record the particulars of debt, any kind of debt, to put it on or place it on or record it on information utility, that is NESL website. A login based service is there wherein after advancing or lending the money, the details are entered and those are to be authenticated by the other party. The corporate debtor have to affix the digital signature and authenticate the claim on the information utility website. Other relevant documents is financial contract, loan agreement, guarantee agreement, hypothecation deed, mortgage deed, the financial statements showing the dates due, ROC charge related documents, SARSAI related charge related filings. So all the supporting documents can be attached along with financial creditors claim. Now claim by class. Class means a group of, we saw the definition of class of or class of creditors. The prescribed form is form CA in electronic form. This has to be submitted. Normally in case of home buyers, a class is there. So a person claiming to a class of creditor may submit a claim to IRP in electronic form CA. Existence of so schedule 1. So existence of debt due may be proved. So what documents are required to be attached? Information utility, records of information utility. Then other relevant documents including agreement for sale, letter of allotment of flat, builder buyer agreement is there, receipts of payments over a period done, and any other communication correspondence, letters which have happened with the builder as regards home unit is there. So letter of allotment, all the relevant documents are required to be attached in case of class of creditors. Like I said, we got an opportunity. One Mumbai-based financial creditor, class of financial creditors was there for which we filed the claims for flat buyers. Around 200 plus flat buyers were there for which we filed these claim forms. We had them in filing, of course. Creditor may or class of creditor may indicate choice of insolvency amongst them to be as authorized representative. So they have to choose an authorized representative being a class. Claims by workman and employees. Here, if it's a single workman or employee, they may submit a claim in Form D. If numerous workmen or employees are there, Form E is there, the prescribed form is there, in which the claims are required to be filed. What are the supporting documents? What can be attached? Of course, information utility, if the data is there, it's not mandatory, if any. Then other relevant documents include proof of employment, contract of employment, offer letter, salary slips, evidence of notice of demanding the payment, and so on. PF related data, gratuity related data. So whatever data is available, that has to be filed with the IRP as regards claiming the amount which is outstanding. While analyzing these claims, as and when IP receives these claims, at the back of the mind, somewhere the waterfall mechanism has to be taken into consideration by an IRP. Of course, that will take place in event of liquidation, not in case of CIRP. But at the back of the mind, he should have a thought process as to where this claim will actually placed out of those 8 entries in section 53. In the waterfall mechanism. Like suppose 3 years salary is due, 3 years salary payment is due, or workers payment is due for 3 years. In that case, workmen are eligible for 24 months payment on priority basis. First is liquidation cost. Secondly is workman's claim for 24 months along with secured creditors who have relinquished the claim. So for 24 months, it will take a priority. For rest of the 12 months amount, it will come down on the 6th number, other category of creditors. So that needs to be ensured. The claim has to be bifurcated in that manner. Similar happens in case of employees. 12 months salary has to be considered on the priority in the list which is there, and rest of the part goes down for other higher amount or amount for the previous period prior to it. So a workman shall attach these documents. Claim by other creditors. Who can be other creditors? Any creditor who is not a financial creditor, not an operational creditor, not an employee, not a workman, nothing is there. Out of nowhere, this person is there who has dues. He doesn't fit into any of the categories. Like, I'm not sure about these examples, but maybe a thought in my mind, maybe share application money has been given by a person and share spending allotment. Shares are not allotted to him during that stage. So that money, I don't think where it fits into any of the categories. Say one more example, if I try to think, in fact, if any of the participants are aware, they can also share their experience as regards this kind of. One more scenario I know, a company which was of course not into real estate business, and there was a land it wanted to sell it. Against that, the advance was taken, and somehow the transaction could not happen, could not take place. It was just an advance given against the land purchase, and later on the transaction was cancelled. The core activity was not real estate activity or selling or land or anything. So in this scenario, it is neither operational debt nor financial debt. It may be categorized into other. Last example, suppose there are preference shares and those are redeemed and the amount is due and not paid. I don't know where this amount fits into. So this may be categorized in that kind of claim. So other claims. Other claims in form F, the existence of claim of creditor may be proved on the basis of record available information and utility, any supporting document which is there, documentary evidence demanding satisfaction of claim, bank statement, and other, and of course court order. Wherever court order is there, tribunal or any some civil court, some tribunal, labor court, any court is there which has passed an order. Sometimes in case of financial creditors, the matter goes, the financial creditors choose to go to under SARFAESI first, or some, in some cases arbitration take place and arbitral awards are there. So those claims are also taken into consideration. Based upon that, the IRP has to take such claims and supporting orders or court orders or tribunal orders as regards claims are concerned. Substantiation of claims and cost. Regulation 10 and 11, substantiation of claim. It may happen that RP might require further data. Some additional data is required by RP. So in that case, he may ask for additional data, documents, information he may ask for. Then to that, the data can be provided and the claim can be supporting document or clarification can be provided. I have certain slides at the end which will be throwing in which I'll be throwing light on the practical aspects of it regarding submission of claim or maintaining the database of the claim or reverting or replying to the RP's query or auto-generated emails of acknowledgement by RP, something like that. So we'll discuss at that time. Then cost, the claimant, of course, the creditor will bear the cost for filing the claim. Suppose some certified copies are to be obtained, some document has to be obtained for filing the claim, or stamp paper notary cost is there. So these are cost related to filing the claim are to be borne by the creditor himself. So he shall bear the cost of it. Moving ahead, submission of claims, Regulation 12. Any doubts, any queries till now? Anything anybody wants to discuss? Throw a light on any of the aspects.
No,
Yes,
nothing.
yeah, we'll continue. So Regulation 12, submission of proof of claim. Regulation 12, creditors shall submit a claim. Now, like I said, there have been certain amendments as regards submission and verification of claims. We'll focus on that. Creditors shall submit a claim with proof on or before the last day mentioned in the public announcement. Now, after the amendment, there are 3 deadlines by which the claim can be submitted. Earlier, what used to happen straight away, a prescribed due date was there, up to which the claim was required to be filed before that date. If that is not filed, straight away the RPs used to reject the claim. That is, this is filed beyond a prescribed limit. You are requested to take appropriate action. So in that case, the matter used to go to adjudicating authority. Adjudicating authority many a times used to pass an order, and then the claim was admitted based upon the orders. Now the scenario has changed. The last day. So what is submission of claim? Regulation 12. Claim has to be submitted on the last date mentioned in the financial statements. Public announcement. Provided that a creditor who fails to submit a claim with proof within the time stipulated in the public announcement may submit a claim. So if he has failed to submit it, he may submit the same to IRP or RP as the case may be up to the date of issue of request for RFRP. So resolution for request is there, 36B, RFRP is there. So up to that date or 90 days of insolvency commencement date, whichever is later. RFRP, till the time the resolution applicant is given RFRP. RFRP is a document which prescribes the methodology in which the resolution plan is filed by resolution applicant. So it's a total plan as to how the resolution plan is required to be filed, the manner in which it has to be filed, the dates and everything. So up to that stage, the claim can be filed. The only thing here to be noted is, so 3 dates trigger over here. Firstly, last date mentioned in the public announcement. Secondly, date of issue of RFRP. So that is somewhere near to the resolution plan. So up to that date and 90 days of insolvency commencement date, whichever is later. The only thing is that if it is beyond 90 days, reason are to be given. Reasons for a delay in submitting the claim are to be given. So if there is a sufficient cause for a delay, only in that case the claim can be filed. So now the ambiguity is gone. Again, the responsibility is cast upon the resolution professional or IRP. Earlier, these matters used to go to adjudicating authority. Now they have extended the based upon the case laws and judgments, because maximum orders were many a times it was a practice that IRP used to reject the claim. It used to go to adjudicating authority, and before the resolution plan is approved, if that claim is there, they used to accept it. So now that has been fixed up over here. A long time span is given. Of course, last date of submission, the claim can be filed, prescribed in public announcement, the claim can be filed. Up to the date of issue of RP with reasons, So reason for delay as to why. And then up to 90 days, whichever is later is the time span prescribed. Where the creditor is a financial creditor. Now what happens if it's a financial creditor? RP or IRP has to include, if the claim is admissible, he has to include him into the COC. Of course, financial creditor form part of COC. They are members of COC, and the claim has in that event they will be allowed to participate in those CSVs. And of course, whatever the earlier meetings have taken place, the validity of those decisions will not get affected. Inclusion shall not affect the validity of decisions taken by the committee of creditors. So again, this amendment may be noted. Earlier, only the time period prescribed in the advertisement was there. So 3 dates are trigger points. Firstly, or deadlines. Firstly, the date prescribed in the advertisement. Before that, I have to file a claim, or 90 days time period, or the date of issue of request for resolution plan under regulation 36B. RFRP is that date is there. Up to that date, I can file a claim. Of course, beyond 90 days, the reason has to be specified. Reasonable cause or has to be shown as to why there was a delay. I was why I was not able to file the claim. Moving ahead, updation of claim. Creditor shall update its claim as and when the claims is satisfied partly or fully from any source or manner after the insolvency commencement date. So updation, we already discussed this. Once a claim is submitted, it may happen that sometimes additional documentation, additional supporting document proof is there. So he may update the claim, which the RP has to take into consideration, and he has to also update the claim amount into it based upon the admission or its rejection. So creditor has a right of updation of claim. Verification of claim. The interim regulation 13, verification of claim. The interim resolution professional or the resolution professional, as the case may be, shall verify the claim within 7 days of receipt of the claim. So 7 days time period is there. Very less time. Overall, the 180 days period is very less. But in this, admission of claim or rejection of claim or verifying the claim within 7 days is very, very difficult. But yes, he has to do that. 7 days from the last date of receipt of claims. And he has to maintain a list of creditors containing names along with amount claimed, the amount of claims admitted, security interest, if any. At the end of the presentation, I have prepared the columns which I have mentioned in what manner the data can be saved or preserved in the Excel sheet. So in respect of such claims and updated, where the interim resolution professional or the professional, as the case may be, does not collate the claim, where claim is not collected, he has to give a reasons, specify the reasons as to why he has not collated or not collected the claims or not verified the claim. He has to provide for the reasons for the same reasons in the writing. In event the claim are received after the period specified. Now 1B, this was inserted by way of amendment in September 23, and this has changed again the cast responsibility, like in order to bring in that line with regulation 12, 90 days or till RFRP date. Now verification also has been changed, the scenario over here. In event of the claims are received after the specified sub-regulation 1 of regulation 12, up to 7 days from the date of meeting of committee of creditors, up to the 7 days before the date of meeting of committee of creditors for resolution plan, approval of resolution plan. So if resolution plan is proposed to be placed before a committee of creditors for approval, before 7 days for that, before 7 days, or initiation of liquidation, as the case may be, the interim resolution professional, now that responsibility is cast upon him till that time. till the time the committee of creditors considers the resolution plan, till that date he has to verify the claims. तब तक claim आएगा, I have to verify those claim, I have to ascertain and on it whether that is acceptable or not acceptable. If that is acceptable, then I have to categorize that as an acceptable claim or not acceptable for collation. I have to determine. Interim resolution, professional resolution, as the case may be, shall firstly intimate the creditor within 7 days thereof the reasons of claim has been not acceptable. So why it is not acceptable, he has to give a reason. And again, put the claim if the claim is acceptable. So those who are not acceptable, you have to give reason why your claim is not acceptable. And wherever the claim is acceptable, put the claim categorized into the next TOC meeting. So the committee of creditors next meeting for recommendation of inclusion of list into the list. So in the list of creditors, see, if you see the many committee of creditors minutes, there is a regular item into the board, the committee of creditors meetings, that latest position or list of creditors is placed, the as and when those are updated. So those are placed before the committee of creditors. So put the claims which are acceptable and collated by him to the committee of creditors at the next meeting for its recommendation for inclusion in list of creditors and the treatment on the resolution plan. What will be treatment on the resolution plan? Why this kind of claim might come? So it may be possibility, of course, late the claim have come, or there are certain transactions, preferential transactions, extortional credit transactions on which order might come, or some contingent claims are there. So based upon that, what will be the impact? See, these all claims are to be considered by the RP into the information memorandum. And of course automatically they will be taken care of in the resolution plan. RP cannot ignore those claims. So even if it is a contingent claim, it is advisable to include all these claims into the information memorandum. A sufficient provision for that has to be made, and automatically in the resolution plan the care is taken off. So when the claim is acceptable, committee of creditors next meeting he has to place before it, and he has to include it for recommendation into for adding the name of the creditor into list of creditors, and what will be the treatment or effect on the resolution plan. Submit such claim before the adjudicating authority for condonation of delay and adjudication. Now here the responsibility is cast upon the RP. Earlier, RP used to straight away send the person to adjudicating authority, the claimant, and he used to say, get your delay condoned. But here it is the RP's responsibility to get the file the claim for condonation of delay. The list of creditors shall be available for inspection of the person submitting the claim. So list, whatever is updated, list is updated on IO's website, corporate debtors website, if any, and regular basis on IBBI website through our login, through the claims, the update and all the data which over a period which is updated, all those lists are available for verification. The latest one is the claim which gives the latest updated claim. So that data is put into the public domain, available for inspection by members, partners, directors, guarantors. It has to be displayed on the website of corporate data and the website of the board. Filed on the electronic platform maintained by the board for disseminating on website, provided that this clause shall apply to the corp. Now this is a transition provision. Before this is then amendment will be applicable to transition provision also. Filed with the adjudicating authority and presented at the first meeting of creditors. So it has to be presented before the meeting of committee of creditors also. So this is a provision as regards verification of claims. This has been an amendment now. So lot of ambiguity, lot of trouble of NCLT or volume of cases will be reduced because of this. So electronic platform of board, we saw that. Then determination of amount of claim. We already discussed this, that wherever the amount is not precise due to its contingency or other reasons, IRP has to exercise its best judgment, shall make the best judgment of the amount based upon it. Insolvency resolution professional or resolution professional, as the case may be, shall revise the amount of claims admitted, including the claims, as soon as practicable when the additional information warranting is revision. So best judgment, I have, because today I don't have the exact amount. Best judgment is exercised in that case. I put it, and later on when some supporting document is there, something is there, I have in my hand, that in that case I can update that amount as per regulation 14. Debt due in foreign currency, what happens if at all claim is there in foreign currency? It's very simple. On the date of insolvency commencement date, the official exchange rate published by RBI has to be taken into consideration, and the claim shall be valued on that official exchange rate on that date. So the amount on that date, exchange rate published by RBI, it has to be converted into Indian rupees and accordingly included into the claim.
Sandeep sir, if you want, and can we have a short break?
Yes, I was willing to have a break around 4 o'clock, but that's fine. We can, if you allow or if participants allow, we can take a 10 minutes, 15 minutes break right now.
Okay, sir. Anytime you want, you can take break.
Okay. So with the permission of participants, shall we stop now or shall we continue for some time?
Okay, no problem.
You may continue.
Yeah, thanks. So maybe around 4 o'clock, we'll take a 10-15 minutes break.
Okay, okay.
Post which we'll discuss the cases or case laws on it. So yes, debt in foreign currency. Now, broad liquidation process. This was about claim submission in case of CIRP, corporate insolvency resolution process. Any participants, any experienced participants wants to discuss something about their experience as regards claim submission of claims in CIRP, because we are theoretical part of it. We have dealt with the theoretical aspect of CIRP, corporate insolvency resolution process, claim submission and verification. Any doubts, any queries, any further suggestions, any experience anybody wants to share? So that we can start with the liquidation process. Yes, we'll proceed. Broad liquidation process. Now, what happens if resolution plan is not approved? And or sometimes creditors pass a resolution that company is CRP not possible. Let's go for liquidation only. In that event, liquidation process starts. How liquidation process goes? Appointment of liquidator, formation of liquidation estate. These are some procedural states. I will also go through the model timeline. Consideration of claims, verification of claims. We'll be focusing again pertaining to liquidation. We'll be verifying the claims or provisions relating to verification of claims pertaining to liquidation now. Admission or rejection of claim, determination of value of claim, appeal to the creditor in case of rejection within 14 days of rejection of claim, liquidator to scrutinize again preferential transaction, overvalue transaction, extortionate credit transactions, distribution of assets, and dissolution of corporate debtor. So this is a flow of liquidation process. Model timeline for liquidation process. Now, model timeline of 365 days has been prescribed for liquidation process. Regulation 47. Again, here we'll be dealing upon, I've highlighted mark in brown these this color pertaining to the claim related things, but this is a model timeline, and of course this is also expected to be followed. T is 0 days where the commencement starts, then the public announcement, appointment of registered valuers for valuation, then first meeting of stakeholders consultation committee within 7 days, submission of claims. Here only 30 days time is there, no extension, no liberty is there. Beyond this, if anything has to be claimed for, the person or the claimant will have to approach the adjudicating authority. Submission of claim, intimation of decision on relinquishment of security interest by the creditors. Secured creditors, section 52, they have an option to relinquish their claim. Withdrawal or modification of claim for 10 days time is there, T plus 44. Verification of claim received from regulation 12(2)(b). Then verification time is 30 days, which is available. Constitution of stakeholders consultation committee. Unlike, see what happens, the committee of creditors have got voting power. In case of liquidation, it is not a committee as such. It is stakeholders consultation committee. They don't have voting power as such, or they are there to consult, or they are there to advise the liquidator. Any decision taken by them is not binding on the liquidator. Of course, whenever the liquidator takes any decision which is against or the otherwise than the decision which is taken by the stakeholders, he have to record the reasons as to why there is a deviation between his decision and the stakeholders consultation committee. And when the progress report is filed with IBBI, he has to give a reasons stating that as to why the reasons as to why deviation is there. So consultation committee is there. There is no voting power as such, or based upon the claim, their voting power as such is not there here. So intimation about decision of acceptance or rejection of claim has to be given within 7 days. Then further 7 days. Then list of stakeholders has to be filed within 45 days. Appeal by the creditor against. So any appeal is there, further period of 14 days has to be preferred to the adjudicating authority. Preliminary report to adjudicating authority within 75 days. Asset memorandum. So the details of asset which are there. So asset memorandum has to be produced, prepared and produced by the liquidator. Submission of process of to the progress reports to the adjudicating authority. Asset sale report to be enclosed. Progress report in case of cessation of liquidator. Information to the secured creditor. Distribution of proceeds to stakeholders. Application to adjudicating authority. Disclaimer of onerous property. Property which cannot be readily sold. So onerous property is disclaimer. Then notice to the person interested in owner's property. Liquidation. So without the notice to the interested person, it cannot be disclaimed. So prior permission is required from that particular person. Liquidation of corporate debtor. Deposit the amount into an undistributed. So like the liquidator is under obligation to open a separate bank account. ABC Private Limited, for example, ABC Private Limited in liquidation. So with that nomenclature, the account has to be opened and entire funds will have to be transferred to that account, and transactions will take place from that transaction. Ultimately, the distribution of funds will take place from that particular account. Time period of H1 bidder, that highest one bidder is there. So for him, the time period is there for 90 days. So this way, the T plus 365 days period is there. 1 year period is there for liquidation process. So we will be now discussing about the regulations pertaining to liquidation. Claim related provisions pertaining to liquidation. So how claim works. Claim under liquidation. Claims under liquidation process, relevant regulations. Now again here the process also starts from public announcement. Here the public announcement has to be given in form number B, of course, of the liquidation regulations, IBBI liquidation regulations. Form number B, schedule 2, 5 days from his appointment. So within 5 days the advertisement has to be published, where stakeholders are called upon to submit their claim or update their claim. Why updation is there? Because at the time of CRP they might have submitted the claim till the date of insolvency commencement date. Now the cutoff date is there for as on liquidation commencement date. So till that date, the claims, maybe interest components is added wherever applicable. Sometimes it may be the same. So the stakeholders are called upon to submit their claim as on date of liquidation commencement date, and provide the last date for submission of updation of claim, which shall be 30 days from date of liquidation commencement date. Like I said, there cannot be extra days or extra period is not there here for liquidation commencement. It is 30 days only. Any claim beyond that, adjudicating authority will have to be approached and the claim will have to be adjudged by the adjudicating authority. What will happen in case of claim which is barred by limitation? In case of CIRP, it is a resolution professional or IRP is not adjudging the claim, a time barred claim, it is advisable to accept the claim, because the job in case of CIRP of liquidator is to collate the claims, and he may advise the or approach the adjudicating authority to get clarity on that, because there may be some aspects, it may be continuing nature of date. So it is not the resolution professional. I'm talking about CRP. In the CRP, time barred date, it is advisable to approach the adjudicating authority and get appropriate directions. Some of the orders are there against passed by disciplinary committee against the IPs, wherein the claim was admitted, although was time barred. So that care has to be taken. Last date 30 days here, provided that stakeholder does not submit a claim. Now what happens if stakeholder does not submit a claim? There is a deeming provision that whatever claim he had submitted at the time of CIRP, that claim shall be deemed to be the claim. That amount will have to be considered. The announcement shall be published. One English newspaper, one vernacular language, a registered office of corporate debtor is situated or location where liquidator is of opinion the corporate debtor conducted or conducts principal business operations. So wherever corporate debtor was operative, on that. So here the discretion is again on the liquidator as to where the advertisement has to be published on the website of corporate debtor, if any. So if the corporate debtor has a website, there definitely the advertisement have to be posted on the website, if any, of designated by the board for that purpose. So we do from our login, we do upload, keep on filing certain data as and when we get assignments. Different forms are there. Like recently, VL forms were there, or liquidation forms were there, through which the data goes and is reflected on the IBBI website. So these public notices are also there on the IBBI website, which can be verified. Submission of claim. Submission of claim. A person who claims to be a stakeholder shall submit its claim. Last date mentioned in the public announcement. So the claim has to be submitted from the last date mentioned in the public announcement or updated. A person shall prove the claim, including the interest, on the liquidation commencement date. It may sometime happen in many of our cases. In one of the cases, it had happened that there was a rented premises, rented registered office, and the landlord filed a claim with with today's date. So there I had to advise him that you revise your invoice and send me the data, or send me the amounts only up to the date of liquidation commencement. Only up to the date of liquidation commencement. Similar kind of situation has happened right now. There is a concept of virtual office. So virtual office is provided for certain companies and they charge some fees for that. So again, rent for registered office. In that, after insolvency commencement date or liquidation commencement date, the claim cannot be admitted. For that further period, we cannot accept the claim. So that has to be limited only up to that, or even interest calculation only will have to be only up to the liquidation commencement date. Claims by operational creditor. Here the categorization is not exactly as like CIRP. Claim by operational creditor provisions are similar, form is different. There we had form B, here it is form C. Again, data, what are the enclosures? The form, embedded affidavit to it, then duly signed, self-signed, all the documents, the KYC documents, information utility data, then contract of sales, supply, goods, services, invoice, purchase order, GST details, tax invoices, TDS certificates, financial statements, email correspondence is there, demands, bank statements to prove the satisfaction of the authority, any court order which is there. Some alternate remedy has been exercised, then any court order is there. So that has to be collated, that has to be collected and submitted along with the claim form. Claim by financial creditor. Here also, care has to be taken that the interest computation will be up to the liquidation commencement date. Same provision as regards CRP. Only thing is form is different. Information utility data, loan agreement, financial creditor, financial contract, record evidencing the amount of the committed default, record of default, bank statements, financial statement showing or any other order of any court or tribunal. Then claim by workmen and employees. Here also similar provision is there. Form E, and where numerous workmen or employees are there, form number F. Existence of workmen to be proved by individually. It may be individually filed or claim or by a group. It will be through, can either be through information utility or proof of employment contract, appointment letter, salary slip, bank statement, any court order, tribunal's order, evidence demanding payment of amount. So that way supporting documents can be attached to that effect. Amount of course has to be calculated up to the date of insolvency commencement date. The liquidator may admit the claim for workman or employee on the, now suppose here there is a specific provision. Suppose the workman fails to file a claim, he has to verify the books of accounts, and based upon that workman's claims are there, those are required to be taken into consideration, admitted even without filing the claim. Liquidator may admit the claim of workman and employee on the basis of books of accounts of corporate debtor if such workman or employee has not made any claim. So workman fails to file the claim, still in the books of accounts, if there is a payment to workman, wages, salary, PF, gratuity, anything, any dues are there in outstanding, he cannot simply ignore that because form is not filed. He can consider those as a claim, and he has to take those into consideration. Claim by other stakeholders. Claim by other stakeholders. Form is different. Otherwise, rest of the provision is same. Supporting documents are required to be attached, like from information utility or documentary evidence to show the amount which is outstanding, or evidence of claim or court order or anything. Proving the security interest. Now, this is slightly different in case of liquidation. This happens slightly different in case of liquidation. Proving security interest, secured or unsecured, because the asset is going to be disposed of now. And Section 52 option is available. If secured debt is there, security interest is created into it. It's up to the creditor whether to relinquish the claim or to enforce the security, and then what actions are to be taken. Proving the security interest. The existence of security interest may be proved by security creditor on the basis of record available in information utility, certificate of registration of charge from ROC. So how it can be proved is certificate of registration of charge from ROC or CERSAI website, we register it for information utility. So security interest has to be proved from the date of registration. There is a provision in Companies Act also where a charge is required to be registered and not registered. It is void in event of in liquidation against the liquidator and creditor. So proof to that effect has to be attached, either information utility or ROC charge documents, including the index of charges on MC website and registration of charge on CERSAI website. Presumption of security interest. Creditor shall inform the liquidator of the decision to relinquish its security interest. If he fails, where the creditor does not intimate such decision, it will be presumed that the security interest be presumed as a part of liquidation estate. So he has to inform specifically that to inform the liquidator decision of relinquish, Section 52. This has to be informed in section form number C and form D of Schedule 2 of liquidation regulations. Documentary evidence in support to that effect, that is agreements, hypothecation deed, mortgage deed, document evidence on notice of demand or payment of debt, documentary of electronic records of each shareholding, other court order or tribunal order. Again, where a secured creditor does not intimate its decision within 30 days from the liquidation commencement date. So from liquidation commencement date within 30 days is to inform whether he is going to relinquish that claim or not relinquish and exercise himself, enforce the security interest himself and realize the amount out of it. The assets covered under this security shall be presumed as liquidation. So if he fails to inform, then the liquidation estate will include that particular asset. Where a secured creditor proceeds to realize the security interest, he shall pay. Now he has not relinquished under Section 52. He himself realizes the amount. What would happen in that case within 90 days of liquidation commencement date? So he shall pay what he has to pay as much towards the amount payable under 53. Like I said, that's why because of this, the RP has to keep in mind the waterfall mechanism, Section 53 also. So as much amount towards the amount payable in clause A or clause 1 or clause B, Section 53, as would be shared in case it had relinquished the claim of security interest to the liquidator within 90 days of the liquidation commencement date, and any excess amount has to be paid. Suppose he has realized the amount, he has to ensure as to how much amount which he is eligible to, whatever amount is stated in Section 53, according to that only he'll take that amount. Any amount surplus or beyond that is there, that amount he has to make it paid to the liquidator. And if at all that amount is not paid, interest has to be paid over it by the liquidator. 12% interest has to be paid, provided that were the amount payable under certain, not certain. Again, certain, the amount is not certain, best judgment estimate has to be exercised. Later on, when the amount becomes certain, the difference will have to be good. Difference between the amount payable under sub-regulation and the amount paid under proviso shall be made good by the secured creditor or the liquidator, as the case may be. So I don't know the certain amount today. So on the basis of best judgment, the amount is transferred, and later on the differential amount either can be refunded or paid. This is in event where the security interest is realized by the creditor himself. Secured creditors fail to comply with subsection 2. Of course, the asset will form part of liquidation estate. As if there was no security interest, it will be treated like that. Production of bill of exchange and promissory note. that is there, such bill of exchange or promissory note. So where it seeks to prove to the satisfaction that bill of exchange or promissory note negotiable instrument is there, such a document has to be provided before the liquidator for its admission. Substantiation of claim, same provision again, that liquidator may call upon additional data, additional evidence which is there. What is the basis of calculation? How we have done the calculation? Whether simple interest, compound interest, how the working has been done. Also, certain additional documents are required. ROC charge document, certificate of registration charge. So he may ask for clarification of further information, and which has to be given to the liquidator in order to, based upon it, for substantiating the part or of the claim. So he may ask for information, and of course that information has to be provided for. Cost of proof: the claimant shall bear the cost of proving the claim. Similar provision. Uh, Cost incurred by liquidator for verification shall form part of liquidation cost, and any cost which is found, any claim is to be found false, then liquidator has to endeavor to recover such cost from such claimant or who is doing the false filing or false claim is being filed by that particular person. Determination of quantum: again this is similar provision where due to its contingency or other reasons the amount cannot be quantified. Best estimate has to be made by the liquidator uh, based upon the information which is available right now on the circumstances. Debt in foreign currency, it remains the same. The provision remains the same. The only thing is that same means like CRP only. There it was liquidation commencement date. There it was in the CRP commencement date. Here it is liquidation commencement date. So the rate prevailing on the insolvency commencement date will have to be taken, and on that the claim will have to be valued in Indian currency on that particular rate or at that particular rate. Periodical payments, I think we already discussed this. Periodical payments, in case of rent, interest, or other payments of periodical nature, person may claim only for the amounts due and unpaid for the liquidation commencement date. So only up to liquidation commencement date the claim can be filed. After that, no claim or no periodical payments will have to be can be filed or will not be admitted. It's a typical mistake which is made, that they do the calculation and the calculation is done till the date of filing the application, which is of course more. Debt payable at future time. Debt payable at future time. So any person may prove for the claim whose payment is not due to liquidator commencement date is entitled to distribution. Now suppose for this I'll give an example. So proportional reduction will have to be made. Similar kind of formula is again given in all voluntary liquidation also. Suppose a borrowing has taken place for 3 years. For 3 years borrowing has taken place, for example 12% per annum interest, and the maturity is after 2 years. 1 year has elapsed, liquidation has taken place, 1 year has gone up to the liquidation commencement date, and 2 more years are to be there. The amount is not yet matured. So a formula is applied by which proportionately the amount is reduced. This is the formula. I have practically never used this formula, but the idea is the claim has to be reduced proportionately. If future date is there, any amount which is there of a security, future maturity is there. So for that, obviously, particular date up to the date of commencement of liquidation, calculation will have to be done, and for rest of the period, the amount will have to be reduced proportionately. For that, this calculation they have given. Mutual credit and set off, that is possible. Simple example they have given: X owes 100 rupees to corporate debtor. Corporate debtor owes 70 rupees to X. After that, 30 rupees. So net off or set off is possible. That provision is there. Earlier, this question used to arise. But again, this ambiguity is fixed by this regulation that set off is possible. I owe certain money to corporate debtor, and corporate debtor also owes certain money to me. Then the net effect can take place. Verification of claims. Should we take a break here? Maybe a 15 minutes break?
Sure, sir.
Yeah, so it is 4:05. We meet at 4:20.
Sure.
Yes. So shall we start?
Yes, sir.
Thank you, ma'am. So regulation 29 we discussed, mutual set off and credit. Then verification of claims. Regulation 30. Liquidator shall verify the claims submitted within 30 days. We saw that the liquidator shall also verify the claims collated during the corporate insolvency process, but not submitted during the. So all those claims also will have to be taken into consideration, which are filed during CIRP. It may happen sometimes that during CIRP the claim was filed, but during liquidation process, in reply to that, the claim was not filed. So liquidator has to take into consideration those claims as well. He cannot simply ignore that. So the claims received during CIRP are to be uh, taken into consideration, and based upon that they may either rejected or the claim may be approved. So that is about verification of claim. Here if you see the difference, like CIRP, in liquidation process there is no extra timeline as such which has been provided, because there has to be some end has to be put to the proceedings. Then again, transfer of debt due to creditors. Transfer is possible during liquidation process. A creditor may assign or transfer the debt due to him to any person during the liquidation process. Liquidator has to take a record of that, and according to the list has to be modified. If both parties are under an obligation to give an intimation to that effect, where a creditor assigns a debt, both parties have to provide liquidator the terms and assignment and transfer, and accordingly the assignment is possible. Regulation 30A allows that. Last regulation in case of liquidation, list of stakeholders. Liquidator, we saw the model timeline in which the liquidator was under an obligation to prepare the list of stakeholders. Liquidator shall prepare list of stakeholder category wise on the basis of proof of claims, amount admitted, amounts extent to which the dues or dates are secured or unsecured, details of stakeholders, proof of admission or rejection, proof wholly rejected. The liquidator shall file list of stakeholders with adjudicating authority within 45 days of receipt of claims. Liquidator shall also apply to adjudicating authority to modify this list when it comes to the additional information warranting such information. Sometimes it may happen that uh, certain transactions are there or contingent liabilities are there, those may be crystallized, which may require the modification in the list. So the liquidator shall modify The liquidator shall modify an entry in the list of stakeholders filed with adjudicating authority in the manner directed by the adjudicating authority while disposing of the. So adjudicating authority may pass appropriate order. List of stakeholders. Again, this is available for verification to inspection by any person who have submitted the claim, inspection by members, partners, directors, guarantors of corporate debtor. That has to be displayed on the website and filed on the electronic platform of the board. So IBB website. Very interesting question. This list is available for verification. This list is available for verification. So can I verify the claims of other creditors? Will RP allow me to verify the claims of other creditors? Any idea? Anybody can throw a light on this? I am a claimant. I have filed a claim, but I want to verify the claims filed by the claim related documents. Is that allowed? Yes, anyone? Can, based upon these provisions or CRP regulations, can I verify the claims filed by other? So the answer to this is no. I can verify the list.
Verification of claims is the prerogative of RP.
Absolutely,
So,
sir.
how any other person or could verify the claim of that other person?
They cannot. They cannot. Agree with you. That data is confidentially kept, secured, password protected with the resolution applicant. But yes, this kind of I don't know if someone has experienced. They ask for verification the basis of others' claims also. So that is not allowed, certainly. He can verify the data which is filed by himself and the list which is available on the portal or which is made available to him. But he cannot simply ask for the claim which has been submitted by other creditors based upon these regulations. Now, practical aspects of claims, which normally we have seen in the claim form. Like I said, RP have to have a lot of patience while dealing with claim forms. These are typical mistakes which are there in the claim forms. Not submitting the prescribed form. We have a case law. We'll be discussing one case law as time permits. A claim was filed in form number C, although was required to be filed in form CA. And later on, at that time, the claim was rejected. Time span was gone, that has expired. And it was held that the form is not mandatory. But it doesn't mean that it is the duty of RP to ensure that appropriate and correct form has been filed. There is a sufficient time, and RP, as a good practice, definitely have to revert and give sufficient time to them that this is not a correct form. Correct form may be provided by RP to them and advise them to submit a correct form. So not submitting the correct form, incomplete form, all the fields are not filled in. Sometimes only signatures are done, notarization is not done, signatures are not done, incorrect or error in forms, erroneous data is there. Many times the calculations part, especially claim amount, there may be a mismatch, which we have seen in the forms. The supporting documents do not provide for the entire amount. Maybe possible that some amount or some claim is not attached. We will be also looking after one case. Recent judgment is there, passed by Honorable NCLAT, wherein based upon the interest act, interest was asked, but financial creditor failed to prove to the satisfaction of adjudicating authority that it was mutually agreed, or there was no document on record which provided for interest component. So in event of that, definitely the interest was not admitted by NCLAT. Sometimes it is also pressure tactic. That if X amount is due, add an interest under MSME Act or add an interest under Interest Act, and so that the amount looks higher, and it may pressurize them to come for settlement. So that kind of tactic is there many a times, or it's always a practice to file a higher amount, a claim on higher side. Insufficient supporting documents in the claim, no proper breakup of principal, interest, damages, penal interest, etc. In case of home buyers, especially, there is a clause for if no delivery or no possession has given, then penal clauses are there, interest clauses are there. Of course, mutually agreed between the parties as builder-buyer agreement. But the exact bifurcation of the amount is required to be given into it. Then error in calculations, we discussed this. Sending claims to incorrect address. In one of my cases, I remember the claim was filed at registered office of the company, and with the promoters, it was sent to the director's email address. All the director's email addresses the claim was sent. It was not sent to me. So sending it to the management and not the liquidator, this also is a practical error, happens many times. No proper signing, notary and stamping of documents. Those are affidavits. Appropriate stamp duty will have to be paid. Every page has to be self-signed. Again, the form also requires for KYC documents. Normally, PAN card, Aadhaar card are required to be attached to it. Non-disclosure of complete or relevant information along with the form. Sometimes certain details are not provided. What we call as concealment of data is also possible. That has to be taken into consideration. Claim amount this is a very common mistake, that claim amount is calculated till the date of submission of claim and not the date of CRAP commencement or liquidation commencement date. So these are some of the common mistakes. Apart from that, you all being IPs carrying out CRP processes, you might have experienced many such practical mistakes, but these are few commons which came to my mind. I experienced this. Tips for claimants for submission. Now, what are the tips for claimants? How do you file the claim? Like I said, when I started the session, I said IBC has got ample of opportunities which are stated in the law and which are also not stated in law. I remember so many times client approach us and they say that, sir, file a claim for us. It may be in liquidation or CRP. choosing appropriate form, doing appropriate calculations, verifying the appropriate documents, appropriate documentation. So a professional can play a very important role as regards filing of claim is concerned. From IP's angle or RP's angle, we look from that side, but from claimant's side also, we can play a very important role of filing a claim. Choose correct claim form and fill it completely and correctly. So entire form has to be filled up correctly. Appropriate form has to be selected. Like I said before, the form is available on the IBBI website under the link downloads. So all those Word formats are available. Arrange the documents with a proper chronology. It is advisable to arrange the document with chronology, proper numbering, clear and legible documents, explaining them as to which document proves what, an exact calculation, separate Excel calculation of interest, whether simple interest, compound interest, what penal charges are there, any amount advance payment. So what was the total amount of transaction? Suppose part payment is, see, many a times ongoing basis business transaction takes place. So it is not bill to bill payment. It is on account payment many a times. So I raised 10 invoices on account 2 lakhs rupees is transport, for example. So in that case, matching that amount and whatever amount is received already, deducting that and correctly calculating the interest to that effect. Affidavit or a declaration which is appended to form, duly signed and notarized along with KYC documents. Proper communication details are to be mentioned in the form. It is advisable to mention proper communication details, mobile number, email address, so that RP can get back to you, can contact you. Proper bank details to be stated, amounts or security interest, etc. Those details, charge creation related documents can be filed and mentioned in the as mentioned in the form. Send physical as well as email scanned copies, although law does not require. What practice we follow is if a claim has to be filed, we generally send the form through speed post RPAD so that the delivery report can be downloaded from the postal website. Also, on the given, once that is sent by post, we scan the postal receipt, scan the entire set before sending, and we send along with postal receipt, attaching that to email. Over email also we send it. What happens? A trail is created. Email trail is created. If auto reply is there, I get an acknowledgement from RP that I have received the claim. Take professional or expert guidance for calculations dealing with work in Excel bifurcation or something. If you're not expert, then take help of some expert in calculation part or presentation part of it. File within prescribed time and respond also clarification. So timeline is also essence, very, very important. So within time, the claim has to be filed and any further requirements are asked for by RP, forthwith or promptly, it is advisable to reply on it. So some of the tips for claimants for submission of claim. Effective process for IPs, IRPs in handling the claim. Now, how do I maintain my database? Firstly, effective process. How do I handle the claims? Some of the tips, practical tips, you being learned professionals, you can also add to it if you have any other point other than this. This is based upon my experience. Now, how IP can effectively handle the claims? Set up self-generated acknowledgement or auto replies are there many times. So auto replies are there so that when an email is received, upon the receipt of the a systematic or separate email address is opened for that purpose. Many times it's not possible for IP to revert, but when the claimant doesn't get any acknowledgement, whether my claim is received by them, considered by them, is under verification, at what stage it is, I don't know. So he gets into panic mode. He will keep calling on. He will sending email over email. So it's better wherever possible, prescribe automatic emails on that email that, okay, we are in receipt of your email. We'll revert on this shortly. So that proves that something has at least some auto-generated acknowledgement takes place. Later on, when time is there, RP may definitely elaborate and reply on it. That is one tip. Then claim form along with documents to be properly segregated according to the type of claim. So while maintaining the records, it is advisable to maintain all the, based upon the nature or type of creditor, the forms to be segregated, properly arranged along with proper tagging, the physical records as well as the electronic record. Not only in case of IP assignments, many other assignments also, what we do is the physical data which is received, we convert that into soft copies and save it on server. So as a backup, it is always advisable to maintain. See, accessing the data also becomes very simple. Carrying the data anywhere, future reference the data becomes very simple. So physical data, maintain it. Apart from that, convert it into soft copies also. Maintaining confidentiality of data, documents, all others. So giving access to this data, like we discussed a while ago, whether others can ask for the claims of others. No, it's a RP's prerogative, like sir rightly said, it is RP's prerogative to verify all these records. And no data access can be given. So password protected and lock-in this can be provided backup at regular intervals. Type or punch in maximum details in Excel. Type it or punch in maximum details in Excel sheet. Excel has multiple features like data filter. If I've created an Excel sheet wherein, for example, amount or name of party or type of or category of creditor is there. So I want to apply a filter and see the claims by operational creditor. Through Excel, I can immediately apply a filter and I can sort the data, and accordingly I'll see that way. So it is advisable to mention maximum data in Excel sheet, feed in the data in Excel sheet only, so that it is within less time, retrieval or accessing the data becomes very simple. Every time you need not go and find out the physical record or scan copy and scan those records. Also, the folder management is very, very important with chronology, sequence, and file name. Proper nomenclature has to be given. I'll show you the manner in which I have given the nomenclature to some of the cases. Not a rocket science, just naming the file as 1, 2, 3, 4 before the name. So it get automatically arranged in that manner. So this can be one methodology, or date-wise or month-wise allocation of folders. Alphabetical manner can be used. So proper chronology or sequence can be maintained. Quick action on all the claims received. See, procrastination is very dangerous. In case of IP assignment, there is a chances multiple things happen and IP is cast upon huge responsibilities. And it may be possible that, okay, I'll see this claim later on, and you park it. There is a chances that you might forget that. So quick action to be taken. Then and there itself, the action can be taken and the claim may be recorded. Communication is forwarded to the creditor. So quick action is very, or prompt action is very important for effective processes of IRP in handling the claims. Proper method to save the data with effective backup system. So data loss should not take place. Nowadays, there is a system of saving the data on cloud as such. So those services can be hired and the data security or can be taken care of. So these are some of the effective tips for IRP and IPs for handling the claim. Going further into this, beyond into this, my personal experience, how I categorize the claims when I receive them. So structuring database in the Excel sheet. You can prepare Excel sheet for, so these are the different sheets which I thought of or we prepare many times with columns, sufficient columns and rows. This is an illustrative list. As per the requirement, the same may be modified. So structuring the database in Excel, once a claim is filed, say primary or basic or general information of claimant may be recorded in one sheet, wherein serial number, date of receipt of claim, full name, complete postal address, email, mobile, type of claimant he is, mode of submission of claim, whether physical or electronic, name of authorized representative, if any, and residential status, whether is in India or foreigner. So this is some basic information which can be prepared in the primary sheet or general information sheet. Second is category or type of claimant. So more details about it, category or type of claimant. So whether correct form is filled based upon the type he has correctly filled in the form, list of enclosures, what documents he have enclosed, relationship with the corporate debtor, yes or no, whether he's a related party or not, nature of relationship. We may ask it from them only. See how do it's very difficult many a times to ascertain the relationship. But from there are methodologies. Free websites are also there through which a person where he is associated as director, where he is associated as designated partner of LLPs or partner of LLPs. So that service is available through internal exercise. IRP also has to do himself the homework to know as to whether this person is related or not. Rather than merely relying on what is filed. So through Dean, through websites, through corporate debtors website, group companies websites, it may be identified where which person is related and what way the relationship is there. So this homework RP is required to do at his end. Whether assignee to the claim, so whether he is assigned to the claim, that can be recorded. So first sheet is general information. Second is category or type of claimant. Thirdly is details of claim amount. Now, detailed bifurcation of the amount, all the aspects of the amount, principal amount, interest, penalty charges, penal charges, if there is a provision, whether security interest is created, particulars of security interest, where it is registered and all, whether SARSAI or ROC website, details, calculation of amount in Excel sheet, proper calculation, details of payments, that is part payment, like I said, ongoing basis transactions are there. Let's say suppose 3 crores was due, but over a period 60-70 lakhs rupees has already been paid. How much amount is it? So it is not bill to bill invoice clearing. On account payment is there. So that kind of system may be followed between the parties based upon their understanding. And details of amount disputed, if any. So this can be the third sheet. First sheet, general information. Secondly, category of claimant. Thirdly, details of the claim amount. Fourth sheet is details of admission rejection. So what action I have taken. Then principal amount, whether I have admitted it or not. Penalty, other charges. Then verification, contingent claim, amount of claim rejected, voting percentage in COC, remarks, if any. So bank details of the claimant, name of bank, branch, account holder. So whenever the remittance has to be done for payment of the amount, then the stakeholders' bank details are to be, their bank details are required. So all the bank details, including MICR, IFSC, branch details, amount remitted, all these details can be maintained in your database. Lastly, the correspondence with the claimant. When the email has received email 1, email 2, email 3, that way, the date of submission, date of receipt of claim. It may happen that there may be a time lag by postal method they have sent the claim and I have received after 2-3 days. So date of receipt and time of receipt of the claim, subsequent communication, if any, trails of emails, time provided for reply, date of subsequent reply. So how much time I have given to them to reply. Further requirement asked for, if any, claim disputed, non-disputed, and remarks, if any. Then primary information about a claimant. Yes. This is an illustrative list prepared as regards attachment of documents along with claim. So along with prescribed form, operational creditor, financial creditor, creditors in class, that is home buyers, workman, authorized representative of workman or other creditor, what documents normally they should attach along with the claim. So this is a summary sheet for the same. That is the list of enclosure. Now we'll go through the DC cases, which I said. I have certain cases or these orders. Immediately after presentation, I'll be sending you the orders. Considering time constraint, my aim is to cover maximum cases, around 15-20 cases I wish to cover. So we'll quickly see as to what violations were happened. Why I've taken the DC orders, I feel that those are more important for us. Updates we go through always, but what while functioning in day-to-day life as an IRP or RP, I should not commit certain mistakes in my professional while performing my professional duties. So we'll be going through the IBBR DC orders. Please allow me to share my screen. I'll share the entire screen again. Okay, you're able to see my screen. You can see the screen.
Yes.
Yeah, thank you, sir. So now the first order. Please allow me to turn off the camera. There's some internet issue. Yeah, so these are some of the recent orders of IBBI. First, the show cause notice was issued and IP gave all the explanations pertaining to it. An application under section was admitted by Delhi court and resolution. He was appointed as IP was appointed as the RP was appointed as IRP. Insolvency professional was appointed as IRP. IBBI appointed an investigation authority, like by the process. which has been prescribed in the regulation. Investigation officer, show cause notice to his replies were found, and IBB upon receipt of reply, show cause notice, responses, and all the supporting documents were sent to the disciplinary committee, and the disciplinary committee then verified the claims, asked for further information and clarifications in the matter. Now, alleged contraventions, these are highlighted in certain colors by me. Admission of claim barred by limitation. Now, actually, it is not a case of barred by limitation. What happened is, Miss Ekta Khare had filed this claim. In this case, the major mistake was committed that NCLT, the adjudicating authority, had passed an order for rejection of this claim. The claim was adjudged and rejected because it was barred by limitation by adjudicating authority. RP, what he did, based upon some legal opinion, he took a legal opinion from law firm, and based upon these paras, any observation made in the order shall not be construed as an expression of opinion of merit of controversy, and right of the petitioner before any other forum shall not be prejudiced on account of dismissal of instant petition. So based upon this sentence, he took legal opinion from some law firm, and then he admitted that claim. So the mistake committed was claim which was time barred by adjudicating authority and rejected by adjudicating authority. Adjudicating authority's order was not complied with. So he submitted that it was diligently followed. He submitted the order to ensure compliance, and legal opinion was also taken. He submitted that the corresponding time barred limitation, all the claims have been live. So if that would have happened, his justification was that considering the time barred provisions of Limitation Act, all claims should have been liable for rejection. So DC noted all these points, and they said that, okay, here it was clear cut based upon the legal opinion. Some legal opinion cannot supersede the powers of NCLT, Honorable NCLT. So bench's order you cannot ignore. DC views that specific order of Honorable NCLT cannot supersede the legal opinion taken from any. Then again, this was first violation, that barred by limitation. So claim barred by limitation was accepted. Then inconsistency in information memorandum and valuation report. So the FAR and non-FAR land. So basically that's a builder's ratio of construction over a land. FAR and non-FAR is ratio is a so this data was not correctly mentioned in the information memorandum, which again had a great impact or huge impact considering the amount into it. Huge impact on the resolution plan. So this affected, like I said, the value lesser than, thereby defeating the provisions of objectives of maximization of value. So because the area stated was less in the information memorandum, there was this was a serious error which was committed on the part of the IP. So he gave the references. His justifications were heard by the DC and finding of the DC. It is pertinent to note that for real estate project, FAR and non-FAR areas are essential, very, very crucial. Here IP also argued that adjudicating authority is not a power in the CRP. It is the adjudicating officers or adjudicating authorities power. I have to just collate the claims. I'm not an adjudicating authority as regards claim is concerned, but the same contents were not accepted. His role is not limited. He takes over. If you see the duties of section 18, he takes over the entire affairs of the corporate person. He has to ensure that the objective of the code is to maximization of value of asset. RP needs to be transparent and facilitate credible determination of value of CD. So they took a view that maximum important data was concealed and which was placed in the information memorandum, due to which the valuation also got reduced. Issue of claim of Evershine Builder. This claim was initially admitted and later on this was reduced. Now, what happened because of this? Why? See, these are again cases related to claim. These are not normal orders. In this case, how the claim has impacted. Because he initially admitted the claim, the voting percentage was huge. So he enjoyed, here they have used this wording, illegally enjoyed the voting power under the CRP. And later on, after the COC meetings, this amount of claim was reduced and the voting percentage was also reduced. So these are the major mistakes which were committed. So this was a stand taken. He was not in a position of books, of accounts and records. Those were in position of certain court. Ghaziabad Nigam Limited, Nigam, the court was there. In view of that, best judgment and whatever data was provided to me, on the basis of that, the claim was verified. So you'll always be careful in dealing the duties and everything. So DC is finding, hence on the date of verification of claim, existence of arbitration award was there. This arbitration award was ignored totally. This was totally ignored. He was aware of it in the COC meetings. The reference of arbitration award was there. Inaction on obtaining records of CD. So this also happened. It is a duty cast upon RP. Section 25 also talks about resolution professionals duties, wherein he is under an obligation to take possession of all the records. Here, he failed to do it. He delayed it unreasonably. He said that the records were there with the appropriate authority, and hence he could not get a hand on the records of it. So if he was aware that there was some flaw in the records, he should not have relied upon it. He filed an application in A against the suspended director of PNB. So all this contention, all this stand was taken. And finally, findings of DC, RP for further information, complete records is not available prior to. So whatever data is not available, he was aware of it. Currently in the process of finding of NCLT to seek the further. So he should have taken NCLT's directions. He did not took that. And now this is the order. It was held that RP has grossly failed to exercise the powers, and thus for 2 years, the hereby suspends the registration. So RP's registration was suspended for 2 years. Few orders, many orders are there of this serious nature. Few orders are there where serious warning is given, or no suspension of degree has taken place. 1 or 2 lakhs rupees penalties have been imposed. This is another case, again, CRP matter. The petitioner's show cause notice was sent, and this is in respect of order passed by principal bench for CRP, wherein he was appointed as an IRP. We are studying these orders for academic purposes, and these are available on IBBA website. So name of IPCs, I'm not reading, no relevance in that. This is just our intention is to study where things went wrong, and that should not happen with R while performing the duties. Some are very, very obvious or naturally things can happen, like placing of certain information on website, where earlier where it was said that website was not there. Yes, coming to this case, section 7, the petition was admitted. IBBI based upon findings again sent a notice, record were asked for DC. Then IBBI the show cause notice along with all supporting documents were forwarded to disciplinary committee. Disciplinary committee in the reply to SN submissions. Now alleged contraventions, differential treatments of different home buyers. So 11 home buyers were there, to which they were categorized as other class of creditors. They did not get the status of home buyers, although they were under the categorization of financial creditor only. They were categorized under different category. So this deviation or this discrimination was done. It is observed that despite having admitted the claim, these decree holders, creditors in class, he treated the claim of the said decree holder as other creditors in the resolution plan. So why other creditors? They were the flat buyers. And again, in this case, only a gross order was there. Whatever money was paid by them was confiscated. Towards the flat, the money was confiscated. The resolution process is meant to help the providing the home buyers to, there is no place for refund even after the decree. So it is observed that home buyers have repeatedly questioned the deliberate act of treating them as other creditors. You did not treat us as home buyers. You treated us as other creditors. The above correspondence clearly shows envisage to hide certain actions. The fact and circumstances are observed in investigation of lack of integrity and negligence is there. Again, for earlier, the justification given was there, certain kind of investigation was carried out against me, but I got a clean chit in that. That basis was taken. Complaint as a mere COC member. IBC does not require resolution professional to review the commercial wisdom of it. That is COC's duties. These all defenses were taken. At some cases, it was admitted that some mistake had taken. He submitted that it followed the process and with proper and due care and consideration. Distinction of decree holder accordingly in the resolution plan was not in contravention of law. That is what stand he took. And let's come to the findings, analysis and findings. Before the deceased treatment of home buyers. So the treatment was gross mistake which was committed. RP has no control over the commercial treatment. So this cannot be taken as a stand. It is RP's duty to categorize the claim. Reliance on the judgment cannot be shield of inconsistent. Now, certain judgments, what they did is several judgments were placed. So reliance on judgments cannot be shield of inconsistent and convoluted and negligent conduct. So you cannot take some cases in your favor and present before us. That was the stand taken. Non-inclusion of provisions of unclaimed units or flat. Now, yeah, this here it happened. So certain claims were not filed. Now, that's why I told that ambiguity has been fixed upon. 6A regulation is there. It states that books of accounts access he has to verify that. So in that, claim were not filed. But there was in the records, books of accounts, there were the number of flats. A list was presented. 281 flats. It was observed in the resolution that where there is no provision for unclaimed flats, in the resolution plan, no claim was made for unclaimed flats. So flats were there, claim were not filed. So that amount they had confiscated. There's no provision for that. The submissions were there, and these are analysis and finding. Non-consideration of such claim, making the value of such nil, forfeiting the part of payment made by such allottees, and cancellation of allotment of such units in resolution plan do not seem to be inequitable. So he should have taken an effort to and contacted those. What was the order? Suspension for 2 years. Another case is there. Here also multiple contraventions have taken place. We'll read quickly through the bullet points. CRP admission case only is there under 218. This section provides for investigation into affairs of intermediaries, that is IP in this case. Show cause notice was sent, show cause notice, and the reply was sent to the disciplinary committee. Issues, contraventions, issue regarding acceptance of claims of financial creditor. So in this also, there was a adjudicating authorities order. There was an adjudicating authorities order wherein this entity, Prayak Polytech, failed to demonstrate the existence of financial debt. It could not show the resolution. And it was not a financial debt, but he was made a part. He was given 100% control, voting control. Again, here also. So there was an NCLT order wherein his question whether he is a financial creditor or not, he failed to demonstrate whether he is a financial debt or not. But just a minute. In spite of that order being there, he was considered as a financial creditor. It was observed from the above that financial claim of Piyush Prayag Infotech against the CD was duly adjudged by adjudicating authority, which held that could not demonstrate. So that party could not demonstrate that he's a financial creditor, and still they were given a financial creditor status and was made a part. What justification he had taken is Form C was filed firstly. Secondly, TDS was deducted on interest. Interest payment was made. The terms and conditions provided for payment of interest in the books of accounts. 26 AS, it was interest. So here they all these sides were presented and all these points were considered. Disciplinary committee held that he was aware that books of accounts are not correctly maintained. Those are partially correct, or those cannot be relied upon. So how you can rely upon selected points for as per your convenience? So formed an opinion that loan given was a money. So how he formed an opinion? On what basis? TDS on interest was deducted. It was shown as long-term liability in the balance sheet without any schedules as such. But these were the findings. And accordingly, it was held that these are the serious violations which have been taken place, certain favorism was passed. NCLT concluded that Prayak Polytech has not been able to demonstrate again the same, that it is not a financial debt. You have an NCLT order wherein it states that it is not a financial debt, and you still ignore that. Certain amount out of 4.50 crores was adjusted and booked later on in the books of accounts and booked as transaction, as sale. So how that can be a loan? All these analysis, detailed investigation according to the chronology of events were studied. These were the submissions made, and ultimately the order was suspension of registration for 1 year. Of course, I'll be sharing these orders. In view of this, why claim filing is important. Filing of claim is very important, or in verification of claim and proper categorization, the manner in which you, because it has impact, like I said, impact on the for entire, it decides the fate of CIRP. Again, he was appointed here. The IP was appointed as RP was appointed as an IRP. Letters and correspondence took place, and contravention of the Constitution of Committee of Credit without verification of claims. So claim forms were not received. What happened? IBBI asked for certain information, which he could not provide. Claims forms were not there. Merely on certain basic documents, the claims were accepted and they were made part of Committee of Creditors. So proper due care was not taken, and without verification of claim, the Committee of Creditors was formed. These were the submissions, analysis and findings. Non-compliance of adjudicating authorities order for submission of proof of claims of COC. So when data was asked for, sufficient data was not maintained, could not provide the data. Reply also was given after 9 months, did not comply with the order of adjudicating authority also. So not appearing before adjudicating authority also. IP has failed in his duties. In spite of repeated follow-ups, he did not appear before adjudicating authority, and he gave some reason. It was not required or something like that for some reasons. But how do the adjudicating authority know? It was directed and he was to appear. Inclusion of related party in CD into COC. Now this happened over here. See, that's why I told he could not make it out. Such a huge, what we call as concert, acting in concert. Hence, there is a connection between CD and it was held that they are acting in concert. So in the Committee of Creditors, these all shareholding and everything was found out. And it was held that they operate in a group. Committee of Creditors is there. And the stand taken was that Bank of India is also one of the COC member. They did not take any objection. So that cannot be a stand. It is our duty to verify. Analysis and findings. These were the relationship. Proper verification took place in this. And it was held that they are acting in concert. Entities in common directorship controlling the entity. So there was a failure on the part of RP as regards compliance of 29A. Backdoor entry was allowed knowingly, unknowingly, don't know, inadvertently. Failure to obtain claim for workers of CD. So a claim was crystallized and order was there. Court order was there for 45.66 crores, but no effort was taken to collect the claims or collect their claim which was there in the books of accounts. He was aware about this order. These are the submissions made in the proper chronology. He said that newspaper advertisement and everything was made. But a claim of workers in audited balance sheet, those were there. So looking at the long-term dues, these are findings. The dues are so long-term. They were part of books of accounts. Fully aware about long-term pendency of workman's dues. So failure for accepting these were part of books of accounts. In spite of this claim was ignored. So duties of IRP, there was a failure. Regulation section 18 and 19 and 20 and 25. 18 talks about duties of IRP. 25 talks about duties of RP. What order was passed? Cancellation of registration. It is cancellation of registration. No further period prescribed. So it was total cancellation. For recent judgments, I have prepared a summary that also I'll quickly go through. I'm sure we should be able to complete it by 5:30. In 20 minutes, I'll cover all these orders. So again, another order. Adjudicating authority admitted the claim. IP was appointed. What was the violation? Delay in verification of claim. So unreasonable delay in verification of claim. Claim verification, there is a prescribed timeline. Justification was given. See, it's not that IBBI doesn't listen to us. IBBI does not take lenient view. It's not like that. I read this order thoroughly. There are certain cases wherein IBBI has taken lenient view. Wherever possible or wherever due diligence or care has been taken, in the order itself, they have admitted that, okay, a lenient view is taken by us on this. So where there is major and serious nature of failure, in that case, yes, there has been a problem. Such kind of orders are there. So breach of moratorium. What happened? Certain payments were moratorium started, but the bank account was operated by old management, and certain payments were made. That siphoning or siphoning of fund could have stopped. So that was not taken place. Immediate steps were not taken place in that. So the bank account was operated and the custody of old suspended directors. Somewhere they have used the word the siphoning could have been avoided. What was the order? Suspension of registration for 1 year. 1 year suspension. Moving ahead, I think let's focus on the bullet points. What contravention or what mistakes took place? These are all relating to claims only. I have digged out around hundreds of orders, out of which claim related orders I have picked them out. So again, a CRP matter. What kind of violation? Non-cooperation with IAs conducting inspection investigation. So non-cooperation. Then here, see, I told you there was a turbulence in his life. So at some cases, they have taken lenient view. They said that DC is inclined to take a lenient view. See, on this count. However, order was passed because the nature of violation which has taken place in other cases. Here he had some serious issues, some relative health issues, some relative got expired, mother passed away or something like that. So lenient view was taken by disciplinary committee. Inclusion of claims of promoters without verification. So claims of promoters was included without verification. That was a violation. All the submissions, proper justification with case laws. Then reduction in the notice period. So below 24 hours, the notice period was reduced. That is again a contravention. In view of above, board is of prima facie the contravention took place. These are the submissions made. Again, non-submission of relationship disclosure. 2018 notification is there of IBBI, wherein all IPs, RPs are required to submit their relationship. By this circular, they have asked us to submit the relationship. IP failed to submit that. Delay in submission of CRP4. So CRP4 is also one form required to be filed within 7 days of RFRP that was not submitted within time. Huge delay took place into that. Appointment of ex-partner and PRA on day-to-day affairs. This is a major mistake which have taken place. A suspended member, board of directors member was appointed as an expert to look after and manage the affairs of corporate debtor into the day-to-day affairs. So sort of like a favorism was passed on. Non-verification of claims of home buyers. Certain home buyers claims were not verified. Not providing supporting documents with COC notices. So when we conduct the meetings, a full set of documents required to be prepared. Upon asking for, the data was not provided. And of course, later on it was produced. Non-disclosure of avoidance transactions. Non-contravention, non-determination of avoidance. So determination was important in case of avoidance transactions. Appropriate application should have been made to the adjudicating authority, which was not made. That was a failure. And what order was passed? Suspension for 2 years. Suspension of registration for 2 years. Let's read out only bullet points. The nature of violation we'll see. So incorrect classification of claim as secured debt. Like I told you that High Court had passed certain order and the wording used was secure the interest of plaintiff. So IP inferred, the resolution professional inferred that secure the interest of plaintiff means this has become secured. So it doesn't become secured. Secured was a dictionary meaning used here. It doesn't mean that a security will be created because of High Court order. So here he failed into this, interpreting the provisions, and he treated it as having security interest into the assets of the corporate debtor. So there was a decree of High Court. So here the order passed was directs undergo a registration. Now our pre-educational course is there. So that course was advised for him, and again, be more careful and cautious. So here no serious order is passed considering the nature of violation which has taken place. Another case, let's see the nature of violation. Issues regarding admission of claim and reconstitution of committee of creditors. Claims and reconstitution was done again to pass on certain favor. Earlier, the committee constitution was different. Later on, it was reconstituted. I think one arbitral award was not taken into consideration as regards the claim amount. Failure of avoidance application. So avoidance application should have been made. That has not been done. Delay in filing the application for extension. So 180 days, it was not the timeline. See, we have to be careful whenever timeline meeting, it is not possible. I think 185th day, 180 days timeline is there. Sufficient care should have been taken to make a petition for extension order. Here, no application was made to adjudicating authority. There was a delay. Violation of board circular, again, filing of certain particulars, it was not done. Appointment of ineligible auditor. So he was a person serving the company earlier, but still was appointed as an auditor, independent auditor. Actually, another CD2 voluntary vending was going on. So that auditor was again appointed over here. So that is again a violation. Non-submission of preliminary report. So here the suspension for 1 year. What order is passed? Suspension for 1 year. Okay, nature of contravention, lack of due diligence in verification of claims. See here only reprimand is there, no suspension. Only there he has been said that be careful while handling these assignments in future. Ensure that no violation take place. Non-appointment of valuers. So from this order, it appears that we have to strictly comply with whatever provisions are there, exactly as prescribed under the regulations. Non-appointment of valuers. Non-cooperation by in conduct of inspection. Delay in filing relationship disclosure. Delay in filing relationship disclosure. Delay in appointment of valuer. What was the order passed? Imposes a penalty. Like I said, see only 2 lakh rupees penalty only means penalty is imposed. Within 45 days, it has to be paid. Here only I mean to say that no suspension has taken place. This is February 24 order. Not very old order. Non-publication of notice. So newspaper advertisement was failure to protect and preserve the assets of CD. Non-publication of, see this on the website. I was talking about disorder. Public announcement was not placed on the website of the CD. So here he took a view that there was no website. However, upon finding out from the past records, it was found out that there was only one website. So to be extremely careful while handling the assignments henceforth. No penalty, no suspension. Last order, non-acceptance of claim. Non-acceptance of claim which was admitted by IRP. Breach of moratorium during the moratorium period. Penalty of 1 lakh rupees is imposed by this order and no suspension. So these are some of the orders relating to claim. I have a quick summary of certain orders which in 5 minutes I'll be discussing. These are regular orders, recent judgments as regards claims. Relating to claims are there. Very recent judgment of NCLAT. So these I'll be just discussing quickly. I prepared a summary for that. So this is the first judgment. Gujarat Urja Vikas Nigam Limited versus Udayraj Patwardhan. What had happened in this case? Any claim arising subsequent to CRP commencement can't be. We saw this provision. We discussed this. CRP date. Any claim arising after CRP date cannot be considered. The claim was rejected. Appellant had no claim as even during moratorium period, certain essential services was stopped. Actually, there was a power purchase agreement between the corporate debtor. Corporate debtor went into liquidation, went into CRP in December 18. Then services for power supply were terminated. Because of this termination, a compensation was appellant issued a termination notice and sought a compensation of 3 crore 36 lakhs. And Form B was filed for that to claim this. And again, the services was stopped. Ideally, cannot stop the essential services during moratorium period, provided that the payment during that period has been made. But mistake was committed to that effect, and claim was filed. There was a delay in filing the claim of 849 days. 849 days delay was there. COC approved the resolution plan. So any claim after approval of resolution plan, the resolution plan was approved by 82.66% of majority. So claim based on assessment after the initiation of CRP and that too after the approval of resolution plan do not stand, and hence the claim was rejected. Honorable NCLT did not allow the acceptance of claim. Capriso Finance Limited versus Trishul Dream Home. Now this is a case. Section 3 interest related case is there. So here the Interest Act, it was alleged that Interest Act provides for that, but there was no document. There was no document which stated or proved that there was some provision for payment of interest. So interest component was rejected. Resolution professional accepted the claim. The principal amount was accepted. He rejected the interest portion because there was no document. Council of Appellant alleged that Interest Act 1978 was there. And based upon that, we have made the submission and added the interest component. But it was held that Section 3 has no application of Interest Act, has no application over here. So adjudicating authority has not erred into it. No error was caused into it. Second number was Income Tax Department. Department of Sales Tax. Sales Tax Department of Claim is there. Department of Sales Tax versus Reliance Communication. What happened? 2 times the claim was filed by here. Firstly, the claim was filed for 94 lakhs rupees. And upon later on, the Sales Tax Department filed a claim of 6 crore 10 lakhs 79,816. So 2 claims were filed. Subsequent claim was filed after approval of resolution plan. So first claim was considered. Subsequent claim cannot be considered. So it was rejected. Claim which was made on the basis of assessment subsequent to the CRP could not be admitted. So we those are find any error or error in the adjudicating authority allowing the application. Then merely format. Now what happened in that case? In this case, I was talking about the format. Form C was filed in this case. Paresh Govindbhai Hirpara versus Prabhat Jain. What has happened? A claim was filed in form number C. CRP commenced on 19th April 23. Form C was filed, and it was well settled. It is well settled now that merely format should not deceive the claim. Proper supporting documents were there, and Form C was filed. Correct form was filed later on after the date. So it was held that adjudicating authority committed an error. The format is not an important thing. He was the first earlier error format was filed within time, and that's why the claim has to be admitted. So what is held here is the format is not important. Now, 2-3 more judgments. NCLT affirms decision of NCLT on rejection of claim due to delayed filing of claim, not aware about liquidation order. So the claim was filed with, of course, almost 3.5 years. 3.5 साल के बाद claim file किया, and with the justification that with the justification that I was not aware about the liquidation. So this claim was rejected. NCLT held that the rejection was correct. Another judgment, Assistant Commissioner of Income Tax, claims made by Income Tax Department in pursuance of assessment were finalized after approval of resolution plan. So claim after resolution plan cannot be accepted. Prior to resolution plan, yes, those can be accepted. Cash payment, cash component, Superintendent of Stamp and Inspector General of Registration. Devesh Thakkar versus Arun Kumar. Issue of claim. Now, what happened here is cash component was paid. In the consideration, what says that the consideration would be paid by check, but actually cash was given. Acceptance of claim in form of cash was rejected. So cash claim could not be accepted. There was no evidence to prove the payment of cash. Claims after resolution plan approved by COC should not be accepted. Superintendents of Stamps. So after resolution plan, the claim was filed. Hence, the claim was not accepted. Another judgment, can claims for tax assessment passed during the moratorium period be considered as unsecured, whereas claims stand prior to admission be secured. So here the corporate debtor was admitted. The CRP admitted on August 17. COC decided to liquidate the entity. Appellant passed an order for attachment of immovable property. Again, rainbow paper judgment is relevant in this case based upon the stand they are filing these cases and requesting or writing the RPs to treat them as secured creditors or security interest. Even resolution plan provides for payment of liabilities under sub judice or undisputed timelines. If no such claim is filed within the time limit, the same cannot be entered in post approval. Same principle again. So post approval resolution plan, it cannot be filed. So this presentation, these case laws and everything I'll be sending across immediately. We have 2-3 minutes time left. If at all any questions, queries, doubts are there, suggestions are there, anything you have to add, we can include that, or otherwise we can conclude. Yes, shall we conclude, ma'am?
If there are no questions, then we can conclude. I am audible, sir?
Yes, ma'am.
Yes, ma'am. Thank you, sir. Nice presentation.
Thank you very much, sir.
Thank you.
It was
For
indeed a very good session, I think.
excellent
Thank you.
session. Thank you very much for giving your valuable time and sharing your experience with the participants.
Thank you, ma'am. Thank you, everyone.
Thank you.
Thank you, Ji. Thank you.